This is Chapter 430, Illinois Compiled Statutes, Act 67, Section 40, right? So the whole Act of 67 is the Firearms Restraining Order Act, okay? And it is amended by changing sections 40, 45, and 55, and we're going to go through that. So before in House Bill 5855, they were talking about it being orders from 6 months to a year. Now they have amended it and changed it to the language that is more suggestive of what is already in place for emergency orders of protection. For those of you all who have heard about these, a petitioner goes before the court, usually ex parte, which is Latin for the other person is not there, the respondent. The petitioner goes by themselves after filling out some documents or things to that effect, alleging that they are in fear of their lives, that this person is trying to harm them, other violations under the Illinois Domestic Violence Act. And then if there is enough information and reason to believe, I believe the standard is clear and convincing evidence. It could be clear and convincing evidence or probable cause, or more likely than not standard. There are various standards in court. Long and short of it, an emergency order of protection is approved, right? That emergency order of protection is only effective for 21 days, at which point in time, if the respondent is served effectively during that time, they have to come to court in 21 days. They come to court in 21 days, and after, appearing before the judge and producing any evidence of the contrary, if the judge approves the order of protection or believes that there's enough information greater than the information provided that was enough to get the emergency order, there would be an order of a plenary order of protection for either 1 or 2 years. So you can see that exact language here in this as well, a plenary order right here. So they struck through 6 months and called it plenary, right? Here we go, 430 ILCS 67, Section 40. A petitioner may request a plenary firearms restraining order for up to 1 year by filing an affidavit or verified pleading alleging that the respondent poses a significant danger of causing personal injury to himself, herself, or another in the near future by having his or her or in her custody or control, purchasing, possessing, or receiving a firearm, ammunition, and firearm parts that could be assembled to make an operable firearm. This petition shall also describe the number, types, locations of any firearms, ammunition, and firearm parts that could be assembled to make an operable firearm presently believed by the petitioner to be possessed or controlled by the respondent. This is the new addendum, right? Or the new addition. The plenary firearms restraining order may be renewed for an additional period of 1 year. B, if the respondent is alleged to pose a significant danger of causing personal injury to an intimate partner, or an intimate partner is alleged to have been the target of a threat or act of violence by the respondent, the petitioner shall make a good faith effort to provide notice to any and all intimate partners of the respondent. You know how that's going to go. The notice must include the duration of time that the petitioner intends to petition the court for a firearms restraining order, and if the petitioner is a law enforcement officer, referral to relevant domestic violence or stalking advocacy or counseling resources if appropriate. The petitioner shall attest to having provided the notice in the filed affidavit or verified pleading if, after making a good faith effort, the petitioner is unable to provide notice to any and all intimate partners. The affidavit or verified pleading should describe what efforts were made. After every person who files a petition for a plenary firearms restraining order, knowing the information provided to the court at any hearing or in the affidavit or verified pleading to be false, is guilty of perjury under Section 32-2 of the Illinois Criminal Code of 2012. Sidebar, they're never going to enforce that. If they do, I'd be surprised. Don't hold your breath. Let's continue. Section D, or number D. Sorry, letter D, you get it. Upon receipt of the petition for a plenary firearms restraining order, the court shall order a hearing within 30 days. In determining whether to issue a firearms restraining order under this section, the court shall consider evidence, including but not limited to the following. It's going to be long. The reckless and unlawful use, display, or brandishing of a firearm, ammunition, and firearm parts that could be assembled to make an operable firearm by the respondent, right? So you might want to stop flashing guns, right? Here we go. The history of use, attempted use, or threatened use of physical force by the respondent against another person. Any prior arrest of the respondent for a felony offense, right? So that's any prior arrest of the respondent for a felony offense. Evidence of the abuse of controlled substances or alcohol by the respondent. So when y'all drink together, they're not going to hold hers against you. They're going to hold yours against you. Better take that into consideration. Let's continue, right? A recent threat of violence or act of violence by the respondent directed towards himself, herself, or another. The fight you got into with your friend, the fight you got into with her friends, the fight you got into with Buddy and them, and you all were clicked up. You and your boo or whomever was clicked up, and y'all nice and fighting and stuff like that. Yeah, that could be used against you, right? A violation of an emergency order of protection issued under Section 217 of the Illinois Domestic Violence Act of 1986, or Section 112A-17 of the Code of Criminal Procedure of 1963, or an order of protection issued under Section 214 of the Illinois Domestic Violence Act of 1986, or Section 112A-14 of the Code of Criminal Procedure of 1963. A pattern of violent acts or violent threats, including, not limited to, violent threats of violence or act of violence by the respondent directed towards himself, herself, or another. That's a lot, right? At a hearing, the petitioner shall have the burden of proving by, remember I said that legal standard, clear and convincing evidence that the respondent poses a significant danger of personal injury to himself, herself, or another by having in his or her custody or control, purchasing, possessing, or receiving a firearm, ammunition, and firearm parts that could be assembled to make an operable firearm. If the court finds that there is clear and convincing evidence to issue a plenary firearms restraining order, the court shall issue a plenary firearms restraining order that shall be in effect for up to 1 year, but not less than 6 months, subject to renewal under Section 45 of this Act or termination under that section. If the court issues a plenary firearms restraining order, it shall, upon a finding of probable cause that the respondent possesses probable cause. Now, this is important because in another state, go follow Armed Scholar, they were talking good cause instead of probable cause. So this section of the bill could make muster, okay? If the court issues a plenary firearms restraining order, it shall, upon a finding of probable cause that the respondent possesses firearms, ammunition, and firearm parts that could be assembled to make an operable firearm, issue a search warrant directing law enforcement agency to seize the respondent's firearms, ammunition, and firearm parts that could be assembled to make an operable firearm. The court, as a part of the warrant, direct law enforcement to search the respondent's residence and other places where the court finds that there is probable cause to believe that he or she is likely to possess the firearms, ammunition, and firearm parts that could be assembled to make an operable firearm. The return of the search warrant shall be filed by the law enforcement agency within 4 days thereafter, setting forth the time, date, and location that the search warrant was executed and what items, if any, were seized. A plenary firearms restraining order shall require the respondent to refrain from having in his or her custody or control, purchasing, possessing, or receiving additional firearms, ammunition, and firearm parts that could be assembled to make an operable firearm for the duration of the order under Section 8.2 of the Firearm Owners Identification Card Act, and that the respondent comply with Section 9.5 of the Firearms Owners Identification Card Act and subsection G of Section 70 of the Firearm Concealed Carry Act. Right? I'm gonna kind of skip through these things. You can read through the rest of this. This is about notice of service. Yeah, feel free to look through the rest of this. Okay, this is important. The person petitioning for the return of his or her firearm, ammunition, and firearm parts, you get the rest of the language, right? Must swear or affirm by affidavit that he or she is one, the lawful owner of the firearms, ammunition, and firearm parts that can make a firearm. Two, shall not transfer the firearm, right, to the respondent. And three, will store the firearms or ammunition so that the person can get a hold of it. This is like if your family member did that. Okay. If the court does not issue a plenary firearms restraining order at the hearing, the court shall dissolve any emergency firearm restraining order then in effect. So what it looks like is, it looks like if they issue it, a hearing is within 30 days, kind of like the order of protection, right? So instead of it being a 21-day, right? Instead of it being a 21-day, it is a 21-day with an emergency order of protection. And then upon the, belief that there is evidence to grant an order of protection, you have a 1 year or 2 year plenary. It seems to be where there's an emergency order of firearms restraining order issued. And then within 30 days, there's a hearing. And then if the court issues a firearm or a plenary of firearms restraining order, that, the court, if the court does not issue a plenary firearms restraining order at the hearing, same process, the court shall dissolve any firearms restraining order then in effect. Same difference, right? When the court issues a plenary firearms restraining order under this section, the court shall inform the respondent that, he or she is entitled to one hearing during the period of the order to request a termination of the order under Section 45 of this act, and shall provide a respondent with the form to request a hearing. That's good, okay? Because at least you get one more time during that time to get your stuff back. A person subject to a firearms restraining order issued under this act may submit one written request at the time during the effective period of the order for a hearing to terminate the order, right? The respondent shall have the burden of proof by proving by a preponderance of the evidence. There's another legal standard. So the first time we heard clear and convincing, this one is preponderance of the evidence, okay? A lot of evidence. That the respondent does not pose a danger of causing personal injury to himself, herself, or another in the near future, and by having his or her custody or control, purchasing, possessing, or receiving a firearm, ammunition, and the parts that can be used to make a firearm. If the court finds after the hearing that the respondent has met their burden, the court shall terminate the order. The petitioner may request a renewal of firearms restraining order at any time within 3 months before the expiration of the firearms restraining order. Okay. You're more than welcome to continue to read this. Ooh, that's a whole nother live. Y'all stay away from troublesome people for sure. It's not worth it. I don't care. Never love someone so hard you lose yourself. Okay. The renewal of a firearms restraining order issued under this section shall be in effect for up to 1 year, subject to termination by further order of the court at a hearing held under this section and by further renewal. Okay, same difference. All All right, unlawful use of a weapon. This is Chapter 720, Illinois Compiled Statutes, Act 5, Section 24-1. And I am struggle streaming.